Good afternoon, everyone. This is Hanonisha speaking. We will give people just a few minutes to continue to join. We know some people have challenges, so just 2 minutes for people to join, and then we will start. Good afternoon, everyone, again. This is Hanonisha Hendricks speaking. I am with Pillar 3 of the GBV committee tasked with implementation of the National Strategic Plan as it relates to Pillar 3 activities. It is also Pillar 3 that is bringing us these webinars that is meant to create awareness and to increase awareness of the amendments that have been brought about by the 3 GBV Acts. Today, we are going to focus on the Domestic Violence Amendment Act, the changes that it brings about, and specifically as it relates to the work that clerks of courts do. And for that, and because it's so specifically relating to the work that clerks of courts do, we have with us Busi Nkosi, who is a magistrate that is well experienced in working at courts and the work that the clerks of the court do. So just before I continue, just a few house rules, as I see that it could impact on what we do here. Please switch off the cameras when you are in the meeting. It influences the ability of everyone to hear as it impacts on the network. Please keep your mic switched off until you will speak or are going to speak or are going to ask a question. It also interferes with the ability of others to hear. For example, at the moment, I see Rendani, Matalisa Rendani and Kanyisile Tabete. Your cameras are still on. If you could just switch it off. Thank you, colleagues.
I've switched off.
Okay, thank you. So as we continue, so Busi will be our presenter today. Busi is currently a senior magistrate, but she holds a BProc, LLB, and LLM degree from the University of Limpopo. She started her career as a public prosecutor in 1995, and then by 1997 she moved to the Nzikasi Magistrate's Office. By 2003, she was appointed as a magistrate, and by 2014, she was appointed as a senior magistrate, and she still holds the position of a senior magistrate. Um, Abusi is, although she can sit and preside over matters in all civil and criminal court matters, her speciality is family law. She currently holds the position of secretary of the Family Law Forum, and she facilitates the family court training for magistrate through SAJE. Busi has a vast experience in her field. She's been in the legal field for more than 20 years. She has a practical knowledge of the implementation of domestic violence and the impact that domestic violence and the regulations have in how we do our work, and especially the impact it has in terms of the work that the clerks of courts do. She is passionate about making sure that survivors of domestic violence receive the assistance that they need through the system. And the clerks of courts being one of the important role players in making sure that people can access the services when they need it. She focuses on making sure that clerks know what the requirements are, know what is expected of them, and know what survivors will be expecting from them. So today she will do training for clerks, focusing on the amendments and the changes that the amendments will bring in terms of the regulations. It is the presentation is the second in the series, and you are welcome to join any one of the presentations that we will have going forward on the clerks of the court. So, Lucy, you may proceed.
Good, good afternoon, colleagues. I believe my slide is visible.
Yes, it is visible, Lucy.
Thank you very much. Colleagues, good afternoon. As it has been said earlier on, we will be dealing with the amendments of the Domestic Violence Act. Now, as a point of departure, what I always say is that when we are dealing with an act of parliament, it's very much important to have the act with you. The act that we are dealing with, you've got the act, you've got the regulations, and then you've got the forms that are found in the regulations. So my plea to you, or to us all, me included, is that each and every domestic violence clerk must have this in his or her possession when dealing with the applications. The most important thing also is the code, domestic violence. As we go on now, you'll see why it is important to know. Because you can't implement something that you know nothing of. You have to have a point of reference every time that when you're assisting the clients. Now, why the amendments? Because we've been having the Domestic Violence Act all along, it has been there. Now, remember, colleagues, the objective of the Domestic Violence Act is to protect victims of gender-based violence. We all know that gender-based violence is rife in South Africa. Hence, the declaration by the state president that it is a second pandemic that we are facing as a country. In the news every day, you'll hear about.
Excuse me.
Oh, sorry.
Excuse me, Busi. Apologies for interrupting.
Okay.
Can you hear me, Busi? It seems that the camera or it has frozen.
I can hear you.
Okay. If you could just lift your camera or your computer screen a little bit so that you are in the center of the picture.
Are you
At the
fine now?
moment, it's cutting your face off. There, perfect, perfect. Lovely. Thank you. Apologies again for interrupting. You may proceed.
Okay, thank you. As I was saying, colleagues, that the question will be why amendments? We all know that gender-based violence is rife in our country. On a daily basis, you hear on the news someone has been killed by their partner or their ex-husband, family member, whatever, for whatever reasons. So the act is there to try and give maximum protection to victims of gender-based violence. The amendments are done in order to cover or close the gaps that were in the previous act and to make sure that victims of gender-based violence or victims of domestic violence get the necessary assistance, the accessibility of the things that they can apply for the orders and any other help that they can get in order to survive the abuse that they are enduring. So I will try to be as practical as possible. You all know that the first section of the act talks to the definitions. The current act has got only 24 definitions. But now when you go to the amendments, you've got 53 definitions. It's not possible for us to know all these definitions by heart. Hence, the need and the emphasis to have the act handy with us every time when we deal with the matters. Now, section 1 gives us the definitions and also the interpretation. The new Hello?
Is the meeting proceeding?
Yes, the meeting is proceeding.
Sir, if you can mute, yes, just mute, keep your mic muted. The training is proceeding. Busi is busy presenting, so if you could keep your mic as well as your camera. Busi, your camera off. Thank you.
Thank you, colleagues. Thank you, colleagues. Now, you'll see on the screen the new definitions that we find in the amendments. Capture, coercive behavior, director general, caregiver, communication, all those definitions. As I said, you don't have to know them by heart. But if you have to check what does capture means in terms of the act, you have to go to section 1 and check that. Because remember, sometimes, colleagues, the ordinary meaning of the word, it's not the same as the act is concerned. All these new terms, they are there. I'm not going to have much time on that. Then you also, when you go to the regulations also contains definitions. That's where you get the definition of electronically, MMS, PDF, older person, SMS, and so on and so forth. Now, let's come to section 1, subsection 2 of the Act. That the section that is the interpretation clause. Now, the interpretation clause tells us who can come and apply. Now, it talks about the complainant. You know, the complainant is the person who is complaining about the Act of Domestic Violence Act. That is the person against whom such acts are being carried out. Now, we know that sometimes a third person can be used. So now, the fact that the applicant is applying for a protection order in terms of the Domestic Violence Act against the respondent does not bar or prevent the complainant from applying in terms of the Protection from Harassment Act against the third party or the other person who is carrying out the dirty works of the respondent. So now, which means you can have the complainant now having two applications, one in terms of the Domestic Violence Act against the respondent who is in a domestic relationship with him or her, and another application in terms of the Protection from Harassment Act against a third party who is not in a domestic relationship with the complainant. Domestic relationship is defined in the definitions. Now, let's look at the stakeholders. Who are the people that are entrusted with the duty of ensuring that the act is carried out? You'll see there, you've got magistrates, justice, police official, correctional official, peace officers, South African Police Service. Then you've got functionaries. Now, functionaries are the people who come across complainants or complainants to be in the carrying on of their duties. Like medical practitioners, see when a person is injured, they will go to see a doctor. Then that's where it will be disclosed that the injury or the stab wound that I have was inflicted by my partner or was inflicted by this other person. You've got educators. Educators at school, they come across or they are with our children on a daily basis. The children sometimes opens up to them and tells them what's happening or what's going on at their homes or what a person has done to them. Or they can spot or note a child who is undergoing domestic violence or abuse, for that matter. Social workers, we know that people go to social workers to report about their social problems. Healthcare personnel, that is your nurses, any other person that you can think of who is providing healthcare services. And then we've got caregivers. Caregivers are the people who are entrusted with caring for other people. It can be an elderly person, it can be a child with disability, can be any other person. And then now it goes on to say any person who has knowledge, belief, or suspicion of acts of domestic violence. Now, any person, colleagues, it refers to every person who is found in the Republic of South Africa, meaning myself and yourselves has got a duty to report acts of domestic violence if we see them happening. We will expand further as we proceed. Then we've got clerk of the courts. Clerk of the courts, they are the face of the domestic violence court, because you are the people that the victims of domestic violence comes into contact with whenever they come to the magistrate office. Now, we've got codified instructions for clerks of the domestic violence court. That was what I was referring to, the code that I was referring to earlier on. Colleagues, I urge you to read the codified instruction for clerks of the domestic violence court. Because if you don't know what is expected from you, the chances of you not being able to carry out your duties are very high. Now, here it says court managers must ensure that office managers, supervisors, and clerks of the court receives updated copies of the Act, the regulations, the code, and these directives. So now, which means court managers and office managers, they've got a duty to ensure that their clerk of the courts are in possession of these, of the Amendment Act. And they must also ensure that their clerks attend annual training on the Act and the regulations. We know things changes. Now, the directives that has been given by the Director General against clerks of the court. It talks to how or when you are supposed to receive the application. Applications for domestic violence, colleagues, are open 24/7. What does that mean? It means any hour of the day, the application, a complainant or an applicant can make his or her application. It's not between 8:15 and 4:15. 24/7, there must be a clerk who is available to assist members of the public with their applications. And the offices can be arranged that there are staggered tea breaks and staggered lunch in order to ensure that there is someone there. After hours, court managers must compile a monthly duty roster for clerks of court for after hours attendance. So there is no excuse to say it's 12 o'clock midnight, so we can't deal with your application. Come back tomorrow morning at 8 o'clock. Any time of the day, members of the community had to be assisted. Why? Because domestic violence applications are urgent matters. To some of the victims, it's a matter of life and death. They might need that urgent protection or imminent protection at 12 o'clock midnight. Now, remember I said court managers must ensure that there is a duty roster on a monthly basis. It's their obligation to ensure that they send the duty roster to the station commanders of the local police stations, which means now if we are saving 3 police stations, make sure that all 3 police stations, they've got the roster of saying who is the clerk on standby and who is the supervisor of the clerk in case they don't get hold of the clerk who to contact. The roster must contain the contact details of all allocated personnel for each shift, time, day, week, or month, as well as the court interpreters. I've included the court interpreters, colleagues, because it depending on the language used. Sometimes there is language barrier. You will need to have a court interpreter on standby. If the magistrate who is supposed to deal with that application can't communicate in the language in the preferred language of the complainant, then there must be an interpreter who will have to interpret to the magistrate. Name and contact details of the supervisor and clerks on duty, and also names and contact details of the court manager. Remember, if the clerk is not there, the supervisor had to come in. If the supervisor is also not there, or there are problems, load shedding, there is no network, whatever the point might be, then the court manager must be able to assist. The roster must also be displayed in the notice board of the court. So it does not only go to the police stations that are served by the court, it must also be displayed on the notice board so that members of the community can see it. It must also be posted on the DOJ website. Why on the DOJ website? As we proceed, we'll be talking about electronic application. So now, if a person wants to make an application through the electronic means, must be able to see the address, see the person, the clerk responsible, and the contact details. And now we come to resources. If now we expect clerks of the court to give assistance or to provide assistance after hours, they must have the necessary resources. So it's the duty of the court manager to ensure that the clerk of the court has, if it means a laptop, have a mini printer, they must have a cell phone with data so that they can be able to access the online applications. As to how that is going to happen, Advocate Praise and her team knows. But it will be a futile exercise to say that people can apply electronically, but then don't provide the necessary tools of trade to the clerk to ensure that such applications are carried out. The supervisor on duty, or the court manager will be the one who will contact the magistrate to say, magistrate, there is an application. Now, what does that mean? It means also on our side, there must be a roster for magistrates who are on standby to deal with this application. Colleagues, this might sound new, but it was there even before with the old act, because with the current act, because applications were expected to deal with applications on a daily basis. And we were having that roster. I don't know other offices, but I know in the office where I am, I've got magistrate on standby to assist with same. Now, we proceed with the duties of the clerk of the court. The clerk of the court is obliged to assist an unrepresented complainant or person applying on behalf of a complainant for a domestic Violence Protection Order. Now, how do you assist? Firstly, there is Form 1, which is called information notice. You have to explain that information notice to the complainant, telling him or her what that he can, what are the options that he has, that he can apply for a protection order, he can lay charges, explain the centers that can assist, and all that is contained on Form 1. Same needs to be explained to the complainant in the language that the complainant understands. After same has been explained, the notice must be given to the complainant, and there must be acknowledgement from the complainant that same has been handed over to him or her. In most of the courts, we are dealing with unsophisticated clients that are unable to read or unable to write. It's the duty of the clerk to read or write. It's the duty of the clerk of the court to assist in taking down the statement of the complainant. Clerk of the court must assist with the application form. Now, if the clerk of the court assists with the taking down of the statement of the complainant, after you have taken it down, the statement must be read back to the complainant so that she confirms, pardon me, colleagues, I will use she, not to say that it can be a he, so that she confirms that the contents of the statement is correct. After the correctness of the content of the statement has been acknowledged by the complainant, then the complainant must sign the said application. Now, it can happen that the complainant has got supporting affidavits from people who witnessed the abuse or who witnessed the act of domestic violence. If complainant has got those supporting affidavits, they must also be part of the proceedings or part of the application. If he has got most material evidence that the complainant wants to submit at that particular time, same must accompany the application. Then we've got safety monitoring notices that can be by the complainant. That is a new thing that has come in. It's new in terms of the amendments. Now, if the complainant and the respondent are staying in the same residence or are sharing the residence, then have also to explain to the complainant that she can apply for a safety monitoring notice. We'll expand on that as we proceed. Now, we spoke about laptops, data, and what have you. Now, that comes in if now the application is made through the electronic platforms. The Amendment Act allows the complainant to make applications at the comfort of their homes, offices, or wherever they are. They can do that through the portal that is going to be created, the electronic portal that is going to be created by the department, or that can do that through fax or email. So now, in that roster, which has got the particulars of the clerk of the court, the email address or the fax number, they must also be included so that if the complainant wants to use that platform, will be able to know which email address to use or which fax number to use. Now, if the application is received through the online portal or through fax or email, the clerk of the court's duty is to allocate a file number and then retrieve all the documents, that is the application form and any other supporting affidavits, and then submit the documents to the magistrate for the consideration of the application. And must also acknowledge receipt thereof to the complainant to say, complainant, I've received your application. I'm now forwarding same to the magistrate for consideration. Now, colleagues, we know that we signed the confidentiality clause. Being a clerk of the court, you will hear people's issues or people's matters that in the normal course of life you wouldn't have known or heard about. So you don't have a right to publicize the people's issues or matters. You must ensure the confidentiality of the documents. Remember, we are at your house when you receive this application. You don't have to share this with your kids. You don't have to share this with your wife. Because remember, another thing that makes people not to come forward and report gender-based violence or domestic abuse, it's because of the stigmatization. They don't. This thing is private. This thing is embarrassing. That my husband is assaulting me, my husband is sexually assaulting me, and all those things. I don't want other people to know. So the confidentiality is very much important. Failure to keep confidentiality, colleagues, it's a misconduct. Now, we know that every document that we get, there must be service. You have to serve a notice to show cause or the interim order or whatever that needs to be served to the respondent or to any other person that the court may direct. It's very much important to stick to the time frames. Manner of service can be by hand, email, SMS, MMS, other social media such as WhatsApp, Facebook, and Twitter. WhatsApp, Facebook, and Twitter, they are normally the last resort. The common one is by hand. Now, if the respondent is playing hide and seek, he can't be found, then the clerk of the court foresees a delay or gets frustrated because now the document they are unable to be served, can approach the court to ask for any other manner of service. So now if the respondent has got the WhatsApp account, a Facebook account, Twitter account, Instagram, whatever account, then the court can direct that the person can be served as such. Last, there was a question that if it's an email, how do you see that it has been delivered? Remember, there is the delivered, think written, what, you must activate that one, that method, print it, put it in the file. It will show that the respondent has read same. WhatsApp, we know that if it's a blue tick, it means that it has been seen by the respondent. You see, we're talking about disciplinary steps for failure to comply with the directives. Colleagues, we don't want to lose your employment just because you failed to comply with the directives. Directives are it's very much important to know them. Hence, I said you have a copy, see the do's and the don'ts. Make sure that you adhere to them. Yes, sometimes there might be problems, but it shouldn't be something that it was done deliberately. Because now you see disciplinary steps for failure to comply is there. That might lead to you losing your employment. The application process for domestic violence. Now, we know we work with jurisdiction as magistrate courts. You must have jurisdiction to hear the matter. Now, Section 12 of the Act talks to jurisdiction. Looking at the way the legislature has said it or has drafted it, I don't see any reason, colleagues, to say that the court has got no jurisdiction. Because it talks about permanent or temporary residents, studies, carries on business, employed of the respondent and the complainant. It talks about the cause of action, where the cause of action arose. And then it further says that no specific minimum period is required for the temporary stay. So now, colleagues, you might have people coming from, let's make an example, from Limpopo, and they go to Mpumalanga, Sabi site for holiday or whatever, and there the acts of domestic violence happens. The complainant can go to Sabi magistrate office to say, to apply for a protection order. You can't say, no, but you're only here on a temporary basis. The fact that they are there for the next coming 10 days or 20 days, or 10 days, they are there on a temporary basis. They are covered by the Act. The problem might be them coming back on the return date. But as the court, we can't say, no, go back to where you come from. They are there, they have to be assisted. This one I've already said that as clerk of the court, you will either get the application electronically via the online portal that the department is going to provide, electronically, but not via the online portal. That will be your email or by fax, or receive the application in person. Those are the normal ones. Those who come into the magistrate court to say, I'm here to make an application for domestic violence. Now, let's check who can bring in the application. Who has the responsibility to bring the application? The complainant, that one is an obvious case, colleague. My husband is abusing me or my boyfriend is abusing me. I'm the complainant. I will come and bring the application. 2, a minor child may bring an application without the assistance or consent of an adult. Here, this one I've seen clerks say sending away minor children. Remember, minor child is any human being who is below the age of 18. Now, if a 16-year-old comes to your court, or a 14-year-old for that matter, even a 10-year-old, if that child comes and it's able to explain explicitly what's happening to him or her, there is no reason for you to turn the child away, because the Act allows such application. Take down the statement of the child. Now, what can happen? The child can be given, the court can then order that assistance be given to the child by the legal aid in ensuring that his application goes forth. Because remember, the abuser might be the parent. The abuser might be the caregiver. So now, if the abuser is the caregiver, do you think the caregiver will allow the child or will accompany the child to come and open and apply for a domestic violence against him or her? Definitely not, colleagues. So a minor child, remember that one, a minor child can come and apply. You know, these children, our children are very clever these days, and they know their rights. They will come. I've seen one this week. I dealt with one where a child came and was complaining about the father. Number 3, it can be a complainant on behalf of their biological child. So now complainant here, then that one, if the parent does not have a problem to accompany the child, it's okay, you can do that. Functionaries, remember I told you who are functionaries. The 5th one is another person on behalf of the complainant with material interest in the well-being of the complainant. Now, 4 and 5, you must have consent, written consent from the person that you are making the application for. Now, a written consent to bring an application on behalf of the complainant, this can be dispensed with, meaning it's not needed if the complainant is a child and the court considers the application in the best interest of the child. That will be now in the instance where the parent comes and, let's say it's the mother who comes with the child and say, I'm applying for a protection order against my husband, who is the father to my child. My husband is abusing my child, he's assaulting my child, or he is whatever abuse that will be alleged. Then the court can dispense with that consent, because now if it considers the application to be in the best interest of the child. Remember, when you're dealing with the children, the best interest of the child are paramount. Or if it's a person who, in the opinion of the court, is unable to provide the required consent. Can be a person who's unconscious, an elderly person who is suffering from dementia, whatever the reason that is given. If the court is saying, okay, allows it, then the application can be brought. Remember I said you have a duty to hand to the complainant to the notice after you have explained what does the notice entails. This is the form that it is in terms of Regulation 8. It is the information notice to complainant who is not represented by a legal practitioner. These are the things that you must explain. It's not, I believe it's not going to be difficult because the things are written there. You just have to read and explain to the complainant if the complainant does not know English, or the form that, and that's the only form that you have. Then you have to explain to the complainant that there's what is available. This is still the form. Then you've got Annexure 2 Form 8, that is confirmation of receipt of Form 8. After you have explained, then the complainant must then acknowledge or confirm that yes, same was explained and same was given to her. We all know that the applications are made ex parte. Ex parte means the other party is not there. It's only the applicant who will be there. That is in the first instance. The application will be lodged with the clerk of the court electronically any time of the day. Yeah. This one I've already explained that can be brought on behalf of another person by a functionary. If the complainant is the child can do it. Can be done by the guardian or the parent. Court can dispense with the. What's important, colleagues, here is that after receiving the application, the clerk of the court must capture the said application in the integrated in the system of the department. There will be a system where the application had to be captured, meaning besides the manual capturing of giving of the file number and what have you, you still have to do the capturing on the system of the department. And the immediately part of it, colleagues, it means immediately after receiving the application, you cannot say I will give the application to the magistrate tomorrow. It must be done immediately. If the application is today, it must be today. Because now, what if you decide that this is not serious, I will only give this to the magistrate tomorrow, and the applicant is killed in between, or something drastic happens to the applicant? Now, the family will be saying the system, the justice system failed our sister, the justice system failed our mother. An application was made, but she did not get assistance. And that might now come back to bite you, to say, but you received the application at 10 o'clock in the evening. Why did you not submit the said application for consideration? This is Form 6. Form 6 is the application form. It gives you the first part is the particulars of the complainant and all that. I'm not going to go through the form. The form that I'm displaying here, there are changes that has been effected on it. So the final form has got some changes. They are not that much, but there are changes, especially on number 3, number 7, and number 8 of the form. This is the form that you have to fill, the application form. And what's important, colleagues, this form at the end, it needs to be commissioned. If it's not commissioned, it's not properly placed before the magistrate. The form must be commissioned by the clerk of the court. The fact that you are the one who took the statement on behalf of the complainant does not bar you from commissioning it. Now, remember we talked about the electronic application. Complainant, it's not before you. How are you going to do the commissioning? Can do it by video call, whereby you let the complainant take the oath, and then you do your commission, and then you commission the application form. Hence, the issue of court managers ensuring that the clerk of the court who is on duty has got data, because this needs to be commissioned. If you place this in front of me without having been commissioned, I'm not going to consider this application. This is annexure to Form 6, which contains personal information. That is where there is information that needs to be kept away from the respondent. Maybe it's the new residential address of the complainant and what have you. Remember, we talked about consent form to apply on behalf of the victim. This is the consent form that must be signed by the complainant to say, Busisiwe, I'm giving Jacqueline the right to make an application on my behalf, and the reason for that must be revealed there in that form, to say because of medical reasons, maybe I was assaulted to such an extent that I'm not in a position to walk to be able to do an application, or for safety reasons I'm in hiding, or any other reason that I will give and the court will consider appropriate. Then the safety monitoring notices. Here, colleagues, it's only when the respondent and the complainant are sharing the resident, then the complainant can apply for a safety monitoring notice. This can be done at the same time when the application is made. It can be done after an interim order has been granted or before a final order has been granted. So anytime during the proceedings, it can be applied for by the complainant who is sharing the same residence with the respondent. What is it for? If the court decides to grant a safety monitoring order, this will be sent to the police station, to the station commander of the police station of which service the area where the complainant stays. whereby they will be requested or they'll be ordered, not requested, they'll be ordered to monitor physically or electronically the complainant. Because now here we are trying to ensure that the complainant is safe. Remember, these people are sharing a house. The acts of domestic violence might continue inside the house, or acts of intimidation or whatever. So now there will be a police officer will be assigned to check on the complainant electronically and physically. The monitoring, this is the application form. It will be for a period of time. And then when the time comes to an end, then the police officer or the station commander, they will give a report to the court to say we were monitoring, we were on a daily basis or twice a week, we'll go to the complainant's house to check how is the going there. She was fine, she was not injured, and all those things. Oh, I called, I spoke to the complainant on such and such a date, and what have you, and what have you. Now, colleagues, we know that people now use electronic means or electronic devices to abuse others or to perpetrate the act of domestic violence. They will use fake accounts or hide themselves. So now what happens now if I'm being abused and I don't know who is the owner of the number or the Facebook page where these acts of domestic violence are carried on? Does that now mean I cannot be protected? I'm a helpless victim. The Act now has got this provision which says if the complainant comes and say, look, I'm receiving these calls threatening me from this number, or this is what is happening, I want you to be assisted. I want to be protected from this abuse. It's hurting me. But I don't know who is the owner. Then that you cannot now say, no, go back. Unfortunately, I can't assist you. You have, as a clerk of the court, you have to take the statement, any other affidavit or supporting documents and submit same for consideration to the magistrate. If the magistrate is of the opinion that, or if the magistrate is convinced that if the identity of the respondent was known, they are going to issue a protection order, then they will now ask the electronic communication service providers to look or to search for the particulars of that person through their systems. Now, which means now the matter will be adjourned while the directive is given to the electronic service provider to look for the information and provide same to the court. That to your electronic service providers, colleagues, we talked about your MTN, your Vodacom, Cell C, whoever that is applying or giving any service of an electronic nature. Now, when the directive is sent to them, they've got 5 days to respond. Now, who will serve the directive of the court to the electronic service provider? The clerk of the court must do that. The preferred manner, it's by email. I think they are going to provide the relevant people to send these applications to or the directives to and their email addresses. So it's important here now also to adhere to the time frames, because now you see they've got 5 days to send you to respond to the court to say we've got the information that we are requesting, or to say we are not providing service to this number. We know there is migration. I might be an 082, but have migrated with my number to cell C. They will tell you, or if they want an extension, they must also request the court that we are still searching, we are providing services to millions of people. So we are still looking for this number. We are asked, or we request for an extension. They will be paid for providing these services. I've seen it says it's 150 rand. So this is the application for Form 16. What's important is that this needs to be monitored, because it becomes an offense on the part of the electronic service provider if they don't comply, and their employees if they don't comply with the directive of the court. So if they've asked for an extension, what the request must be sent to the magistrate, who must make his or her decision whether he's granting or not granting. If there is a response to say we are unable to locate, also that must be put in front of the magistrate, who will then give directive that, okay, so see, you're exonerated from this directive or not. The proof of service, when we talk to service of documents, it's very much important. It must be there, filed in the file, and also in the integrated electronic repository, that is the electronic portal of the department. This is the court order regarding payment of cost. Remember, I said they have to be paid for their services. They will be providing a service, which then they had to be paid for it. It can be by her, the service, the payment can be, the court can order that it be paid by the department or any other person. So if there is an order to say who must pay, that order must also be served by the clerk, either by hand or electronically, to the person ordered to make such payment. This is what I was talking to, that there are time frames. They must respond to the directive within 5 days and what have you. This is the response of the ECSP, of the electronic service provider. This is the affidavit that they must use. So now, remember, they don't have this. So when the directive is sent to them, send them also the affidavit that they must use in order to respond to the directive of the court. So all the directive. This is the request for an extension. That is, if they are still looking for the information that is requested, or the even the cancellation. A request for cancellation, it can be because they don't provide the services, or the information that you have requesting is not there. Remember, sometimes you might be requesting information. You've got the number, you've got the person, but you need information that has been deleted. Remember, in their systems, they store this information, they've got them. If the court can still request for additional evidence, it depends on what is requested from them and what is it that they have provided to the court. This is the form. The forms are there, colleagues. You just go through them, you will know them. Remember, this is there also on the Protection from Harassment Act. So this has all now been brought in the Domestic Violence Act. This talks to the electronic service provider. Now, there is a duty also on the electronic service provider before they dispatch the information to court. If they found the information requested in the directive, they've got an obligation to inform the respondent, that is the person that they are providing services to, that the Polokwane Magistrate Court has requested us to give information, certain information, and we're now going to provide this information to them. They must do that 48 hours before dispatching such information. See, we know the POPI Act and all that. The other party must know. You can't just send information of another person to other people without their consent or their knowledge. Now, said the application it must be placed before a magistrate for consideration. Everything that is submitted as soon as reasonably possible. That's one, colleagues, I want to emphasize, as soon as reasonably possible. We know we've got 1 magistrate stations. You'll find that the magistrate is in court the whole day up until 4 o'clock. Because now it's 4 o'clock, you cannot say to the complainant, it's time up, come back tomorrow. We have to wait for the magistrate to come out of court and give or submit the application to the magistrate at that time. Remember, we said as soon as reasonably possible, and applications can be made at any time of the day. This is the consideration of the application by the magistrate. Can be done on papers. It can be done by leading viva voce, meaning if the statement that is before the magistrate, if the magistrate decides I need more from the statement. Because colleagues, you know, the importance of the statement. You see, sometimes you get a statement which is saying, I'm complaining about my husband who's abusing me a lot, full stop. Now, as a magistrate, you don't know what kind of abuse is the complainant talking about, what is it that has happened, and all those things. So it's important to take a detailed statement. If the Form 2 is not enough, use an annexure, put an annexure there. It needs to be a detailed statement because remember, the magistrate must apply his or her mind to the application. All acts of domestic violence must be there. These are saying that if there are minor additions, magistrate can ask for further affidavits or can take viva voce evidence, take evidence under oath. If there is prima facie evidence that complainant is suffering or may suffer harm, that respondent is committing acts of domestic violence, then an interim protection order will be issued. If there is no interim protection order issued, then there will be a notice to show cause that is issued to the respondent. Your duty here is to make sure that whatever the court decides, it's brought to the attention of the respondent, meaning the respondent is served. If the application is electronically, the applicant or the complainant is not before the magistrate, physically before the magistrate, it's also the duty of the clerk to ensure that the outcome of the application are brought to the attention of the applicant, of the complainant or applicant. Okay, this one is it's for the court to do. It's what the court needs to do. You need not concern yourself with. In some instances, the matters can be sent to the children's court or can be forwarded to the family advocate's office. It all depends what's the evidence there. Now, remember, with the interim protection order, there might also be the safety monitoring notice. Now, if there, or it might be the notice to show cause. Now, these things, all this, if they needs to be served to the respondent, the safety monitoring notice need to be served to the station commander. The importance of service, colleagues, if there is an interim order and it's not served on the respondent, it serves no purpose. There is no protection for the victim, because now the respondent does not know that there is an interim protection order granted against him. And for a breach of a protection order, the person against whom the order was granted must have knowledge of the order. So it's very much important. Service is of utmost importance. Service can be effected by the clerk of the court or peace officer identified by the court. I know in most instances, subs are the one that assist with service of these documents. Now, if the court issues an interim order, same, it must be captured in the integrated electronic repository. So now you've got a dual duty. You do it manually, you must also do it on the system. I think this will assist colleagues, because now you'll find that one complainant has got 3 or 4 protection orders of the same nature issued from different courts. So now if they are there they are captured in the integrated electronic repository, once there is another application, it will reflect there. You'll see already there is a protection order here. Because what the victims do sometimes, when it gets lost, they don't come back to say, I've lost it. They will come and apply and keep quiet, not say that I already have a protection order. And at the end of the day, you are sitting with 3 or 4 files again, which talks to the very same issue against the same people. Now, when you receive the return of service, you must make sure that it's captured and also put in the file. The interim protection order remains in force until it is set aside by a competent court. This is the interim protection order. It's there in your forms. That is for your form 12. Now, remember, with the interim protection order, the court must also issue a warrant of arrest, so that if there is a breach, the complainant can go to the police station with same. Now, the warrant of arrest that the court issues, the issuing of the warrant of arrest happens on the same day when the interim protection order is issued. But then same is kept in the file until now the clerk receives back the return of service. And then same must then now be given to the complainant, and also certified copies of the interim order and the warrant of arrest must be taken to the police station. It must also be uploaded. What you do manually, you must also do on the system, colleagues. Very much important. This is the safety monitoring notice. This is the safety monitoring notice. It's here form 33. If it has been issued by the court, it then must be served on the station commander. Also, the respondent must be served with the safety monitoring notice, meaning the respondent must know that there is such a notice that has been given or that has been granted by the court. This is the report or that they must be brought back to court after the expiry of the period determined by the court. It must then be sent back to the court where it says where he outlines what is it that he has done. Say details of all other instances that I made contact with the complainant with dates and actions or steps took are as follows. We'll write there on such and such a date, I went to the complainant's residence, such and such a date, I contacted the complainant telephonically, and so on and so forth. Now, we know that if the court does not decide to grant an interim order, it will give a notice to show cause. Notice to show cause also, it must be served on the respondent, calling upon the respondent on the return date to come give or to come show cause to the court why the order should not be granted. So remember I said whatever decision that the court takes, the clerk of the court has the duty to inform the complainant, especially with the applications that will be done remotely. So if the complainant is before court, the court will have to explain to the complainant to say, I'm not granting an interim order, but the notice to show cause, give reasons for saying, must come, the court date is this date. Clerk of the court capture the service on the respondent on the integrated electronic repository. The capturing, it's important. This is the notice to show cause, the form that must be sent to service of documents, may be served on the residence of the respondent, place of employment, business, where the respondent studies or personally. If there are problems with the service, clerk of the court, you don't keep quiet. You go back to the magistrate to say there are problems with the manner that the court has said the documents must be served. Can the court grant an alternative way or an alternative manner of service? You see Regulation 11 says the certified copies of the interim protection order application and any supporting affidavits must be served as soon as possible, but not later than 12 hours if served electronically. See, that one is easy, because immediately you get the interim protection order and you've got the electronic address of the respondent, you send it within 12 hours. If it's going to be personal service, says not later than 24 hours. See now, this tells you the urgency of the matter, that these are urgent application. And don't forget to notify the applicant or the complainant of the decision of the court if the application is electronically. And remember, you send certified copies, colleagues, not the original, certified copies. Same applies if there is a final order, they must be served on the respondent and also on the South African Police Services, that is the police station that has been chosen by the applicant. Colleagues, we are humming my ears, please. Now, the sheriff can also be used But in most instances, we know that the people that we serve, the victims of domestic violence, they are people that are unsophisticated. They don't have the money, because when you involve the sheriff needs to be paid. So I've never used the sheriff ever since. We've used the police, some members of SAPS, because I know the complainant need not pay for that service. This is what I was saying earlier on, that you must inform the complainant of the outcome of the application and the capturing. These are additional duties of the clerk of the court in terms of Regulation 9.2, the capturing of the document. You see, these are the duties. So now, which means if you don't capture, that's the relation of duties, which might lead to you being charged for misconduct.
Excuse me, Busi. Cindy, you are not muted. We can hear you. You are causing some interference in the presentation. Can you please mute?
Thank you. Okay. The manner of service of the notice to show cause also is you do it in the manner prescribed by Regulation 2. That is electronically, by hand or by hand. Clerk of the court, after an interim order has been made. Remember now, another order that the court can give is to remove or disable access to electronic communication. So now, if there is an order to that effect, it is the duty of the clerk of the court to ensure that the order is served on the electronic communication service provider. This is whereby now the court will say, okay, because this person is using this device or this platform to bully or to abuse the complainant, it needs to be disabled. So now the clerk of the court must serve to the electronic service provider to say, disable Facebook, Twitter, TikTok, whatever the platform that is. That will be the order that is issued by the magistrate, which must be served by the court. Orders regarding weapons. In some instances, the respondents will use weapons such as firearms or any other dangerous weapon. If that is the case, then the court must order SAPS to seize the said weapon. And after SAPS has seized the said weapon, they've got an obligation to put it under their control. It doesn't matter here, colleagues, whether the respondent is a security officer or it's a police officer who needs his firearm for carrying out his duties. If there are allegations and the court gives an order, same needs to be seized or taken away from the respondent. That is now, court will only do that after considering the evidence that has been given to it, that the complainant or the respondent or the respondent is threatening to kill, injure himself or the applicant or whatever or whoever with the firearm. Now, if court makes such an order, the order must be served on SAPS by clerk of the court. Again, the clerk of the court has got the duty and an obligation to make copies of the evidence that was tendered to court available to SAPS. Why must the evidence that was tendered to court be given? Why must it be given to SAPS? It's because, colleagues, whether the accused is fit and proper to possess a firearm in the future, that lies in the hands of the South African Police Services. They are the one who makes that determination. The court cannot make such a determination. So it's important, hence the importance of ensuring that the evidence that was tendered to court is also made available to SAPS so that they know what to do. Or when they make their decision, they will also take into consideration that evidence. Yeah, here on the return date, we know that that is when now the trial will proceed. Books, documents, videos, photographs, any other object can be submitted to court as an evidential material. Witness subpoena to testify. If there is a person that is needed to come and give evidence, it will be the duty of the clerk to make sure that the subpoena to that witness is served. And if a person, you have to serve that. If the person, the court wants certain to be made available, or a USB audio clip or whatever, or a document, then they can provide same to the court, or they can object to say, no, we're not going to provide same to the court. We will come to court and defend the order that was given by the court. Now, if there is such, clerk of the court must issue the subpoena, as I've said, by hand or electronically. The subpoena must be served on that person at least 10 days before the date of hearing. The 10 days, they are very much important, colleagues, because now if there is short service and the person does not come to court, the court's hands are tied. You can't now issue a warrant and say the person is in contempt of court. So it's very much important to adhere to the period. So also the courts, when they give the period, they must give allowance for the 10 days to say if it's served, it should be 10 days before the date of hearing. Because if it's served today for tomorrow and the person does not come, will you say the person is in contempt of court? It's not. The capturing also comes in. You must capture same on the ICMS and the integrated electronic repository. Yes, I've already explained to you that it's either we will send the document or say, no, I'm coming to object or to defend the order given against me. Now, hearing of evidence of witnesses can be done via audiovisual link rather than in person. So now we know, like Vodacom's headquarters, they are in Midrand, if I'm not mistaken, I believe. Now, the person is sitting in Midrand, is expected to come and give evidence in Cape Town. So it's going to be costly for that person, for the state to pay, or for that person to move. So such evidence can be heard via audiovisual link. So the necessary arrangement needs to be made by the clerk of the court, court manager, court concern, to say that to ensure that on that day the audiovisual link is in place, all is well, and then allow that person to give evidence through the link rather than him or her driving all the way or flying all the way to the said court. Adjournment of proceedings. What's important here is that if the proceedings are adjourned and there are any parties that needs to be subpoenaed, still it's the responsibility of the clerk of the court to make sure that those people are subpoenaed. This is a court order for the extension or discharge of an interim protection order. It can happen that on the return date, for one reason or the other, the interim order needs to be extended. Because now, if there is no extension of the interim order, it falls off. Or there is a discharge of the interim order, then this is the relevant form that the magistrate will have to use. The clerk of the court has a duty to notify complainant or respondent or about the extension or no extension. Set notice of next date of the hearing, served by hand or electronically. If same can't be effected, you approach the court for authorization of an alternative manner of service. See now, the Act is flexible enough that any manner of service can be used. So you cannot say it's by hand, you are unable to find it. Electronic or by email, you are unable to find it. If it's active on Facebook, can be saved there. Taking into consideration the objective of the Act, the maximum protection, we need to try by all means to ensure that victims of domestic violence are given the necessary protection. Now, this is the form that the clerk of the court will use to request for alternative method of service. Then there's this court order authorizing same. Once service is effected, the clerk of the court must capture the Form 2 and return of service on the ICMS, record the information relating to the integrated electronic repository. This is the hearing. It talks about proper service. Now, I've said who must ensure that proper service is effected. It's the clerk of the court. Although you're asking the police to do the service, make sure that whatever documents that needs to be served are sent to the police immediately after they've been issued by the court, so that there is proper service. The court will now proceed to hear the matter. If there is no proper service, it now creates problem, because now there must be a reissue of the notice to show cause because there was no service or because there is short service. This is the form that we use when granting a final order after an interim protection order was used. They are not the same. It has been like that all along. This is a financial protection order where interim order was not issued, with separate forms. Now, this one is used to be a problem in practice. I'm glad it's now there in the Act. It's in black and white. But when the interim order was granted, when the complainant it does not appear, what should happen? Is the court must extend the interim protection order. Now, if there is an extension, what should then happen? It means now the clerk of the court must inform the complainant about the extension of the interim protection order and the return date. And when both are absent on the return date, here, colleagues, the trick is sometimes the complainant are not before court because they don't want to be before court. Maybe they've been intimidated. Sometimes they've been locked into the house, and then now the respondent comes to court and say, yeah, she's not here. I want my matter to be finalized, while knowing very well what he has done to the complainant. Sometimes I'll do the calling around, ask the clerk of the court to check, try to call the complainant, find out where is she. Why is he not in court? Sometimes maybe it's transport problems. It does not have transport money to come to court. Can be, yes, sometimes they are no longer interested, but we need to have that empathy to try and find out as to why the complainant is not before court. Because most of the reason they came to apply in the first instance is because they are being abused. And it was not for the first time. By the time they come to court, this thing has been going on for some time. And remember, domestic violence affects people in different ways. Some, they go into depression. It affects them mentally, physically, and otherwise. So what's important is that if there is an extension by the court, then clerk of the court needs to notify the parties of the new date. Or the court may discharge the interim protection order if the complainant does not appear on the extended date. That is, you give it one more try. So I know sometimes say, 9 o'clock, the complainant is not before court, struck off the roll. No, hold on the file a bit. Maybe they're still coming, transport problems or whatever. Have to call around, find out what's going on. If there is a notice to show cause, if the respondent appears but not the complainant, the court may, after due consideration of any evidence received in terms of the application, set a new return date for hearing of oral evidence. Same applies here. The clerk of the court must assist, must make sure that the new date is given to the parties. This is the court order for the extension or discharge. The importance, colleagues, is that whatever direction or order that the court gives, it must be served. And the responsibility to ensure that same is served lies with the clerk of the court. See, whenever service by hand is required, clerk of the court must certified documents must served on that person electronically or by hand. Regulation 32, if you just make a note, Regulation 32, that is a very important regulation as far as you are concerned when it comes to service. This one I've already said. The warrant of arrest is issued at the time when the order is made, the interim order is made, but will only be given to the complainant after service, not when there is breach, after service. Because now, if the warrant is kept in the file or is kept in the magistrate office, and there is a breach, 12 o'clock midnight, are you saying now what must the complainant do? Because there is an order, there is a warrant. So after the service, it must be given to the complainant, not after breach. I know there is that school of thoughts that they only grant it after breach. No. If the complainant abuses it or whatever, then there are civil claims. The circumstances of same will be will be looked at. So don't shy away and say, yeah, we can't give it to them because they will abuse it. No. You see, this section, the clerk of the court must capture the final protection order, the warrant of arrest, the return of service, the copy of the final protection order and warrant of arrest on the complainant, and on the integrated electronic repository. Very much important, colleagues. Orders that the court may make, I'm not going to dwell on that. It's for the magistrate. Only said that whatever you are expected to serve either on the respondent or any other person that the court orders, you got the duty to ensure that same is served within the stipulated period. Just go back a bit, previous one. The clerk of the court must inform the relevant station commander and national commissioner if a final protection order is granted, whereby a weapon or a firearm is involved, because now the provisions of Section 102 of the Firearms Controls Act comes to play. The application for variation or setting aside, we will get the application. The application for variation or setting aside can either come from the applicant or from the respondent. When you get the application for same, you take the statement, and remember, and then now same must also be served on the respondent, and then you bring the application to the attention of the court. This is the application form for variation and setting aside. This is the notice that is sent to the other party to say, I'm going to apply for a variation or setting aside of the protection order that was granted against me or that was granted against you on such and such a date at the magistrate court. The Act says then 48 hours, within 48 hours. That will be the end, colleagues. Yeah, thank you.
Thank you, Busi, for the presentation. Again, thank you for the practical way in which you explain the obligations and what is expected of clerks. There were a few questions on the chat. We can go through those questions. It was basically 3 questions, but other than that, people are welcome to raise their hands to pose questions. To start us off, one of the questions was, would the clerks as the supervisors have to be available 24/7, meaning including public holidays? This is a question from David Ramolibe.
Yeah, and unfortunately, colleagues, that's the thing. So now if we are on standby Christmas Day, we must make sure that you are sober-minded, because you might be requested to go and do the application electronically or in person. If they say now the applicant does not have the electronic means to do the application, it means now you have to go to the courthouse to do the application. So yes, 24/7, it means every second, every minute, every hour of the day, there must be someone available for the applications. Thank you, sir.
Thank you, Busi. I think it's great that there will be availability on public holidays also. Everyone knows that it's actually during public holidays, especially when people are exposed to acts of domestic violence and they need protection. And if we are not available on those days, then they continue to suffer. And the outcome could be the worst outcome, meaning femicide, if we are not available. So I think that is great that we are making ourselves available all the time to protect our citizens. The next question, it was, what do we do in instances where the clerks only accept applications in the mornings and turn away complainants who arrive at court later in the day?
Colleagues, that is misconduct. You cannot do that. You know, at 4:15, when I'm about to leave to go, I'll go via the clerk of the court and say, do you still have applications? That's misconduct. You cannot. Even if they arrive at 5:45, you have to notify the magistrate who's in the family court to say, Madam or Mr., there is an application. I'm still taking the statement, so that they will wait for that. You can't turn away people. As I've said, colleagues, that you see the danger of turning away a person. You turn away a person and that person got killed. The whole media will be after you. Our sister, our mother went to magistrate court, Malamlela, she was turned away, she was not assisted. People need to be assisted. Even with the current act, it says the application can be done at any time of the day. So there is no reason to turn away people. No reason at all. Thank you.
Thank you, Busi. Then there's one hand from Tembesile. Go ahead, Tembesile.
Colleagues, thank you very much for the opportunity. We highly appreciate the presentation for today, and I'm so happy maybe to share that even the magistrate court, I can see it's still aligned with everything that has been shared today. And I'll also advise our colleagues to also utilize the opportunity of working with different stakeholders. For instance, in our court, we are part of Tutuzela. We are part of our governing body and Tutuzela stakeholders, where we work together with SAPS and also all organizations and government departments, where we are able to share cases whenever that they happen. That means we work 24/7 hours. We're always available to share the cases. But now the challenge that we are facing, which we have been trying by all means to address, and I'm not sure either the action that we used to take, it's worth it. It's when our clients come with bruises and they want to open the protection order, but then they haven't opened the case from the SAPS, or they went to the SAPS to open the case, but then they were not assisted. They were just told to go and open a protection order. My worry about that is that when one comes with the scars or comes with the bruises or comes with a sign of a step in their boot, shows that that was attempted murder, then there is no case open. Yes, we'll proceed with our action of opening the protection order, which will take those days. But at the end, sometimes I used to feel still our clients are not safe. Our SAPS are not helping us. What we usually used to do, which I am on an edge of being corrected if maybe we are wrong. We used to give them the protection order application, but also write a note to the police station to say, can they not deprive them to open a case? Let them open the case because the perpetrator needs to be removed from the space of the victim so that during this application, the victim can be safe. But I'm standing corrected if maybe we are doing it wrong. Thank you very much.
You are correct. That's a problem that we are all facing. People go to the police station and say they want to open cases, even rape cases for that matter. And they will be turned away and say, go and apply for protection order. When you go through the statement and what have you, then ask, but what's going on here? Why are you not opening a criminal case? They will tell you the police said no, because he's my boyfriend or because he's my husband. If I open the case, he'll be arrested and what have you and what have you. But it's all about, we need to preach, keep on preaching the gospel. It's happening. Sometimes it's the other way around. When you say, but you are injured, why don't you also open a criminal case together with the domestic violence project? Said, no, I don't want him to be arrested. I just want him to be reprimanded. And remember, you can't force the complainant to open a criminal case. But if they want to, and the police are the one who are chasing them away. I also sometimes I'll have to even call the station commander to say, station commander, I'm sending a person back to a police station because at the church office he was turned back and she wants to open a criminal charge and she needs to be assisted. Then they are assisted like that. It happens. But I think it's something that as we do our court and case flow management meetings as stakeholders, we need to discuss, talk about it, and hopefully it will end or it will be eradicated. We don't know, but yeah, that's the thing. It's there. Thank you.
Thank you, Busi. Non-Tobeka, her question related to what would happen on the return date if the applicant does not avail herself, but the respondent is there. How does it affect the status of the application? I believe you have answered it in the presentation, but Nontobeka, if you are not covered, just indicate. And then there was a question. If the applicant does not know the person, how do you prove the domestic relationship? This is from Asiya Khan, the question.
Okay, yeah, I've seen that one. My view, sorry. Okay, thank you, Notobek, said I'm covered, thank you. Okay, my view is that, you see, based on what is happening based on what the respondent or the unknown respondent is doing or is saying, you might have an idea, because remember, there is also, the act also covers ex-boyfriend, in-laws, and what have you, and what have you, and what have you. You might have a suspicion that this is my ex-boyfriend. Like, let's say with the posting of nude photos. You know that the person that you send your nude photos to, it's your ex-boyfriend. Now he is exposing those nude photos on TikTok using a handle that can't be identified, or using another Facebook account. So if it centers on those lines, I'm of the view that the application can be made in terms of the Domestic Violence Act. But then it centers on other things, then the Protection from Harassment Act will be the proper act to use. I believe the information that you receive as the clerk of the court will guide you or will give you an idea of what is going on. If you are not sure, you can discuss same with the clerk of with your supervisor, or even with the magistrate, or with your magistrate, to say, no, there is this application. Because sometimes there is suspicion that the account that is being used or the number that is being used, but then there is question. So if it sets us off the view that the person used the Domestic Violence Act, but yeah, that's my view, colleagues. Because remember, this is a new act that will be coming into operation, I think, by the 1st of August, if that's what we are looking at, my mom. But then there will be challenges, yes, but we'll have to deal with them as we proceed. Because another thing which I've seen the definitions, and there is a court case which limits the definition of a domestic relationship. So that was also a question mark on my head, looking at all those relationships that has been listed there, that will it suffice? But I think as we go on, things will be clearer. I've seen someone talking about Labor Relations Act, private life, and what have you. I don't know, colleagues, I'm not the labor expert, but I believe if a person is on standby, that is overtime, and people will be compensated for their time. I believe that will be the thing. So, but the senior officials from the department, I think they've seen that question. They will deal with it as we proceed. Thank you.
Yes, I want to acknowledge Martin had a question on labor relations as well with regard to salaries. So Martin's question and Clive's question, that is something that your teams will probably be dealing with when you raise it with them. But then Clive and I think it was Nelly had a similar type of question. Clark's question was, how do clerks ensure that the other stakeholders fulfills their role in terms of this process after they have, registered the application? Nelly saying that what should she do when the magistrate tells her you don't take applications at 4 o'clock in the afternoon, I assume.
Report sent to the supervisor, who will report to the court manager. The court manager will then report to the head of court that we are sitting with this problem. That's the way to go. The issue of stakeholders, and as I've said, they are there and we are still going to face them. We should shy away from that. But in the local court and case flow management meetings, that's where we need to talk about these things. That SAPS, you send everyone to the police station, magistrate court to manage domestic violence. Even people who only want to open cases, we do that. And if locally it's not set, we go out to there are forums which goes up to the national level. So if there are problems, there are blockages, they need to be reported to the supervisors, to court managers, heads of courts, so that they can be taken step by step up until to the national level.
Thank you, Busi. We have hands. Vusi Samson, and then Faith Mapukata. Can you go ahead? Vusi starting, please.
Okay, my name is Vusi from Mokanzan Court. I just want to ask two questions actually. That because it's my understanding is that we have to submit the roster at the police station. Does the station commander be briefed about this development? And then the second part, if you don't have a sitting magistrate and you rely from other magistrates from other courts, and then is it the duty of the court manager, office manager to get that roster from the chief magistrate, or you can also get it from the police station? That's the only two questions that I have. And the other one, I think they've answered me, the issue of you cannot force someone to open a case while he's been or she's been assaulted. Just the two questions that I have.
Okay, thank you. The Act imposes on every stakeholder to have someone of the and even there we go to the process magistrate. And oh, Jesus. And the thing is, when we do changes, right, that there should be rosters and heads of courts must do those. I think if there is no resident magistrate, there must be some arrangement. There must be some arrangement. And as these applications can be done electronically, even if that magistrate, maybe it's about 100 km away from the courthouse, then the magistrate can deal with that application electronically, so, and send it back to you, who will then also now, after you have received it, then dispatch it to there should be some that are made as to whom must those applications be sent. The issue of training, there have been training going around for different stakeholders. Police are being trained also. But yes, on the ground, there will be problems. But then we shouldn't shy away from assisting because there are problems. We need to try and resolve the problems that are on the ground. Colleagues, please, those who are talking, just unmute your mics. because they are causing a havoc on my ears. Unless you are talking to everyone. But if you are talking to the colleague who's next to you, make sure that you are muted. Thank you.
Thank you, Busi. I see Faith's hand is no longer up. Margaret, you would want to go ahead, Margaret Buffetti.
Good afternoon, colleagues. My name is Margaret Buffetti from Brayton Magistrate Court. I would like to find out what guarantees the safety of public officials in instances where the applicant is in no position to complete an electronic application. So they call the number on the notice board, let's say around 12 midnight, and they want to apply for a protection order. What guarantees our safety in such instances?
Margaret, I'll leave that one for the senior officials of DOJ. I'll leave that one to them. They've noted it. I believe they will respond in due course. Because yes, you are true, it's true. People are naughty outside. They might see your numbers at the notice on the notice board and say, I'm unable to do this thing electronically. I'm at the courthouse, at the gate, or I am at the police station. I want to make an application, whereas that's not the case. So as to the safety of officials, I believe even us included as magistrate, because we'll be expected to go and deal with that application. As to what guarantees our safety, Advocate Praise, I'll leave that in your capable hands.
Thank you, Busi. Then the last and Masana. Can you go ahead, please?
How are you? How are you, colleagues?
Good, thank you.
Yes, I'm not Masana, but Masana, she's my supervisor. My name is Ronald Kwinika. I'm using a phone. I'm the one who's working as a clerk of the court. So I want to ask that in which condition are we allowed to issue notice? And then in which condition are we allowed to issue interim? Please come back to me. Thank you.
Mister, you don't issue anything. Your duty as the clerk of the court is to take the statement of the complainant and any other supporting evidence, and you place same to the magistrate. The person who decides whether to issue an interim order or to issue a notice to show cause, it's the magistrate. If in your court you are told to do that, hey, something is not right. Your duty is to do Form 2, put the forms in the file. That will be the interim order, the notice to show cause, the warrant, because you don't know what's going to be the decision of the magistrate. And place that file in the table of the magistrate. The magistrate is the one who must decide, not you. Please, colleagues, not you. Don't even do calling letters. I know sometimes you do calling letters, say you're calling the other party. A calling letter, it's no, you are not allowed to do a calling letter. It's not an official document. So your duty is to take that statement, whatever evidence, and place it in front of the magistrate. Thank you.
Thank you, everyone. I want to give Advocate Praise Kambula a chance to come in and speak. She will also take it forward and close the meeting or the session. Thank you.
So I can unmute. Mute.
Thank you. Thank you so much, Senior Magistrate Busi Nkosi. Very informative, engaging, and impeccable presentation. We really, really appreciate it. and also the moderation that has been done by Ananisha, who is the co-convener for Pillar 3. So thank you so much. I would like before then we can close. I would like just to respond just to a number of questions that came through. All right, that first. I would like just to say this first is that we have an engagement that we have an engagement with the Chief Magistrate Forum, particularly the committee that deals with the issues of family law and so on. So we will be going back to them to ask them to amend their guidelines on domestic violence now that we have the regulations. And I would like also to say that the final set of regulations is available. So we'll be expect the publication thereof very soon. So we will be having this, we'll be requesting them to amend their guidelines on domestic violence to ensure that the issues of the on-call lists, and availability after hours and so on, it's included in their guidelines. And secondly, we are also looking at, because we already have, as you know, that we do have the integrated case management system, which then the Act refers to it as the integrated electronic repository. So now we are deliberating as a department as to, do we change the name of this system and align it with what the Act refers to, all right, so as to ensure that there is no conflict in terms of the names of these two repositories. So it's something that we're looking into. And but right now, as you know, that there are so many issues that have been raised by the regulations and the Domestic Violence Amendment Act. So the process that we are doing right now is to align then the ICMS, as we call it. We are aligning it with the regulations and the Domestic Violence Amendment Act and its regulations, so as to include, extra data metrics that we do not have right now, issues of the domestic violence, safety monitoring and notice, those orders. Then we need to capture that information. We also need to capture information according to age, because now we have older persons that will be protected. Children, of course, we do have, we're taking statistics in terms of children and so on, but now we need to have data metrics that will be speaking directly to the types of disabilities and also the age groups and so on. It's something, it's work that has already been done, but right now it is about aligning, then checking every data metrics. Is it now in accordance with all the changes that have been incorporated in the final regulations? So it's work that is being done. Now, as we have right now, the online solution for applications for protection orders, which the Act requires that they be done. It's some work that is done by the taking in the protection orders and processing them. That is the clerks of the court. But now what we are looking phase 2 of this project, because we have it's already there. So now phase 2 of this project, and I would also like, before I can move on, to say that phase 1 of the online application has already been adopted by the NSP Pillar 3. all right? So presented there, they saw it, how it's going to function, and it does have functionalities that are allowing the third-party applicants and you know, meaning that the mother can actually apply for protection order on behalf of the daughter using the online application, all right? So it does have those functionalities and so on. So, but now we have to, phase 2 is to integrate this system, integrate it with the SAPS system. And that is work that will be done by IJS. They have asked us to give them a period of about 12 months to do that. So is to integrate the two systems so as to ensure that then SAPS and DOJ have a platform where they are engaging and sharing information. And this is going to be helping us then in issues of us sharing the on-call lists, all right? Sharing information that there's a protection order that is coming, all right? The service is done online. Boom, it goes to SAPS. We want something that is going to be like that, so as to avoid the issues of, you know, printing and to make it completely 100% online and the different stakeholders to be communicating on that online platform. But what is good is that we already have the transversal hub, all right, the IJS transversal hub that's going to be assisting us then where SAPS is already there and DOJ is already there and the NPA is already there. You know, all these key stakeholders, and DSD is also featuring there. Can I ask those people who are talking to switch off your mics, please? And so then the issue of safety, all right, we will definitely not allow any person to go to court without the protection of SAPS. And this is an engagement. SAPS now is busy finalizing their national instructions. It is something that we will ensure that it is included there, because we don't want a situation of people going there, even if you have your car. But we understand that some of our clerks do not have cars, all right? So it's something that will definitely not, even if it's going to be the official car, please don't go unaccompanied. So there must be then, you know, the link between all these on-call lists, all right? The one for the judiciary, the one for the clerks, and the one for SAPS, all right? So that this team works together and know that today we are the 3 people who will be considering these applications. And this is going to be on daily basis. As we have heard the senior magistrate here telling us that it's going to be 24/7 services.
uri nita richava kukurimisa vatu vafika resida kuti ikumbharena musi iwamba tiri kuti tichitesa vachimwanaiwamba rukulu kutula ti
But when I'm in charge, like, what phenomenon I seen very aching it.
Advocate Kambule, you muted yourself. We can't hear anything.
Hi, I didn't know that I muted myself. All right, thank you so much. I would like to, what I was saying is, first I was just thanking the senior magistrate Businkosi for the comprehensive presentation that she has made. And it becomes bigger and bigger as she's presenting, because this is the second round of the presentation. And also the moderation that has been done by Onanisha. Onanisha is the co-convener for pillar 3, sorry. Now, as I was ending, I didn't know that my mic is off. As I was ending, thanks for that. As I was ending, I was saying that we are having engagements with the regional court, the Chief Magistrate Forum. So now we are going to request them to amend their national guidelines, so as to incorporate all these changes, all right? And particularly the issues of the online applications, how they're going to be engaging on them, development of their on-call list and so on, and ensure that they are integrated with the on-call list for the clerks and the on-call list for the police. And it's something that we are also, as police now are finalizing their national instructions, all right? So we want this to be also incorporated there, so that we have then the integrated list of these 3 parties that will be critical in this process. That is the magistrates that are on call, the clerks that are on call, and also then the police that are on call. So in terms of safety, there is no way that we will allow any clerk, even if you have the official car that is, we will not allow anyone to go to court, all right, without the company of the police who is on call, all right? So this, we want it then to be included in the national instructions, and also the guidelines for the magistrates and on, so that then we don't have a situation of the clerks that are going to court without the protection of the subs officials. All right. So then now, coming to an end, all right, is to say this, that we have here on this platform the members, officials from the provincial officers. We also have the court managers, I have been made to believe that, and supervisors. Now, with this information that has been provided here, all right, as we have seen it, that Ms. Nkosi has put it in a very rudimentary approach, taken that approach, it's elementary, it explains it thoroughly, all right? And the slides are easy to follow. And this is something that she has assisted us with, all right? So now, we'll be giving you these slides, okay? So that you put together your mentorship program. And this is a process that will be led by the provincial office, working then with the local officers to start those mentorship sessions, so that each and every court has a mentor, and they've gone through the process of mentorship. The reason for that is because if the Domestic Violence Amendment Act, it came up with a lot of changes. It's a lot of changes. It's like it has been, the architecture is almost completely changed, all right? So then we need then the discourse to continue, all right? And even if you have gone to that mentorship session or go to the sessions that will be continued by Justice College, because Justice College started with the training on the Amendment Act, but now needs to continue with the training on regulations, all right? So this one is a combination of the Amendment Act and the regulations. So then we need that training to continue. So set aside as a court manager time, all right? Set aside time, so even if it's 1 hour, where then you'll be looking into these things and also noting down, because it's a new act, all right? So noting down all those practical challenges that you are experiencing, all right? And find ways then of how we're going to be addressing these, locally, or taking them up then to the provincial office, and so that then we are able then to address those things nationally, all right? So basically that is what we will be requesting you to do after this this presentation, all right? So it's going to be sent then not only to the regional or the provincial offices, as we call them now, is also going to be sent to you. So if you have your email address here, you can get this presentation. You are not going to wait for the provincial office to send it to you, all right? So put in here your email address, all right, so that you get it. And secondly, it's going to be uploaded on our YouTube channel, all right, the department's YouTube channel, and it's also going to the NSP, the GBVF NSP YouTube channel, and we are also then GCIS. We are working with GCIS in our webinar series, so they will also then ensure that there's a spread of these presentations, all right, that will be going to the YouTube channels of the relevant government departments. So we want this information to spread and end, all right? And our department, our communications right now is busy putting together the communication products that will be available to you as a clerk, in our Genie and so on, so that you have all this information in a way that's going to be easy to understand, all right? And the other thing then, which is going to be the last then, is to say that we are the prescribed forms, all right, because you know that the prescribed forms of the Principal Act are available in all official languages. So now we were waiting for the final product of the regulations. So we do have now the final set of the regulations. So now we are starting then with a process then of ensuring that all of them are translated into 11 official languages that then will be available on Genie. So when a victim then needs to speak Xhosa, as I'm a Xhosa woman, then you'll be able to draw that one from Genie, all right? So basically, that's my parting shot for this session. And once again, we thank so much our senior magistrate, because to put together a work like this is quite huge, all right? Because if you look at the regulations, it's like a huge document, and she had to take that document and link it with the Amendment Act, and also look at the directives, putting them all together, for us. So it's not an easy job to do. So we really appreciate it. And I'm hoping that I'm gonna be talking with her, out of this meeting, requesting that she joins us in Cape Town, all right, because we're moving to Cape Town next week to do then the contact workshop for the 3 Amendment Acts, not one. Now I'm inviting everyone to attend then the next webinars that we are having, and I will ask, if you drop your email address here, you will also be getting the entire schedule, all right, for the webinars. And we have been requested then to move on with these webinars because of the quality of the seasoned presentations that are coming through. And so it's coming from civil society organizations, government departments are requesting us that we move on with the webinars. And also our deputy minister has requested that even in August, let's run with this because of the excellent quality of these presentations. So we will definitely be doing that and meeting with you again then in those sessions. So with that, then that's my parting shot, and would request you that to move on. And today, as I speak right now, there's another one is that I have put it here on the chat that is going on right now that I will be joining, which is on psychosocial services by the Department of Social Development, and others are coming that will be talking about very, very, very interesting topics, all right, that you need to know about, even the issue of sentencing, the issue of we're going to be covering different topics, all right, and there's one that's going to be coming on disabilities as well, all right, the handbook that we have put together on disabilities that talk to the attitudes, all right, so please attend that one as well. It's going to be on the 29th, and we'll ensure that our courts do attend it. So thank you so much. Then it takes me to the end. I'm closing then the session, but before I can do that, I'm going to just give Ms. Nkosi the parting shot, to give us her parting shot.
Colleagues, thank you very much for the opportunity. I believe the interaction was worth a while. And if there are any further engagement that you would like us to have, you can email me, we can talk. But hopefully we will get it right. It might look like it's going to be difficult, but I believe we are going to get it right. Thank you very much, Advocate Chris, for the opportunity. Thanks.
Thank you. Thank you so much. Thank you so much for assisting the department. Now, colleagues, let's meet at the next webinar that is already going on right now. Thank you. See you there on that platform. Thank you. Bye.
Which webinar?
There is one. It is the chat. Check the chat. Check the chat. Is there on the chat? Bye.